Arbitration has the opportunity to be a lot more flexible, a lot quicker, speedier, and more efficient than litigation processes allow. So arbitration is like hiring a private judge, but there are a bunch of really important ways that arbitration is different than going to court, right? Where you have a public judge. The difference is are firstly that arbitration is private, right? The fact of the matter is that court files are part of the public record. In family matters in British Columbia, not everybody can see those things, right? It's limited to people who are lawyers and people who are the parties involved. But you can still be in the middle of a trial and have a grade 10 civics class troop in to watch the cross-examination of your spouse, which maybe isn't the best thing in the world, right? And we all know the famous stories about people whose divorces have been splashed all over the front page of the Vancouver Sun and things like that. So first advantage of arbitration, it's private. Your decision, the arbitrator's award, is kept private between the two of you, and it will never be published on the internet, right? Your child will never have to worry about going to school and having their classmates tease them about the recent court decision between their parents, right? The other one of the other reasons why court is different, or why arbitration is different, is that it's like hiring a private judge, except that you get to pick the judge. You can go to court, but who you get is randomly chosen. You have no ability to influence the outcome of that. And the person you get may or may not be a specialist in family law. On the other hand, when you hire an arbitrator, not only can you choose somebody who is an expert in family law, but you can choose somebody who's an expert in the particular part of family law that is the most difficult for you, such as parenting issues, dealing with problems in different jurisdictions, dealing with issues about family violence or parental alienation, or dealing with issues about parenting arrangements. So you can choose the person who's going to be your private judge. And then the third reason, and probably the most important reason, is that when you're in court in front of a judge, the processes that apply to your case are the same processes that apply to the people who were in a car accident, the people who can't agree about where the fence was built. They're the same processes that apply when TD Bank sues RBC about some banking issue or whatever the problem is, right? But in arbitration, you don't have to have that full meal deal kind of approach. You can work with the arbitrator to design a dispute resolution process that is no more complicated, no more expensive, and no more time consuming than what the complexity of the issues, the value of the issues, or your circumstances require. Sure, you can have an arbitration process that looks just like court. And if you want that, it's yours. But on the other hand, me and other arbitrators have successfully resolved disputes using no more than the written arguments of counsel, the lawyers, or we've resolved disputes with evidence that consists of affidavits or answers to questions called interrogatories that need to be answered on the oath of the person who's answering the questions. There's so many other ways. We can even agree that, well, I know you want 10 witnesses, but you can have 2. And I know you want 2 days to cross-examine each witness, but you can have 2 hours, right? So there are so many ways that the traditional court process, which can be time-consuming and incredibly inefficient, can be compressed and shaped and designed to not just everybody's dispute, which is how the courts have to work, that one-size-fits-all kind of approach, not just every dispute, but your dispute in particular.